morning. This is the Citrus County Planning and Development Commission public hearing for October 6, 2022. If you'd like to join us at this time, I invite you to please stand for the invocation and remain standing for the Pledge of Allegiance.
Dear Lord, please give us the grace to be understanding, patient, and tolerant. With these attributes, we can conduct our work in a manner which will be pleasing to Thee, our county, and its residents. In the Lord's name, amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good morning, Cheryl. If you could do the roll call for us, please.
Yes, sir. Good morning.
Good morning.
The following Planning and Development Commission members are present this morning. Robert Bass, Chair. Stacy Worthington, First Vice Chair. James Royce, Second Vice Chair. Carol Scragg, Alternate. David Bramblett, Michael Facemeyer, and Kurt Stone.
Thank you very much. If any person decides to appeal any decision made by the Commission with respect to any matter considered at this hearing, he or she will need a record of the proceedings, and for such purpose, he or she may need to ensure that a verbatim record of the proceedings is made, which record includes testimony and evidence upon which the appeal is based. During public, during public input portions of the meeting, individuals are given 3 minutes, representatives of an organization are given 5 minutes. When anyone wishing to speak comes to the podium, please complete a yellow form to hand to the recording secretary. Please print your name, address, and the number of the application for which you are speaking on the form. The yellow forms can be found at the podium by the door. If representing an organization, a letter of authorization must accompany the speaker. Comments will be limited to the topic being heard. Please state your name, spell your last name, and give your address for the tape record. This is an opportunity for the public to come forward to address any items they wish at this time. Any takers? Seeing none, we have minutes from September 1st, 2022. We have a motion to accept.
Mr. Chairman, I move that we approve the minutes of September the 1st, 2022 as submitted.
Do we have a second?
Second.
We have a first from Commissioner Facemeyer and a second from Commissioner Worthington. All in favor signify by saying aye.
Aye.
Opposed? Motion carries. Staff announcements.
We're going to let the county attorney take the staff announcement today because I don't have anything else. Go ahead.
I just wanted to take a minute, if I could, and introduce Kim Harrison. She's a new attorney with our office. She's been with us for about 3 months, and she comes to us from the state attorney's office. So,
Welcome.
Good morning and welcome aboard.
her first PDC meeting.
You'll find that it's so spine tingling.
Spine tingling. Okay.
You're scaring me.
Doesn't take much, does it, Jim?
When were those?
Yeah, I've totally not been here for those.
Ex parte communications, if we could have our county attorney again.
Yes, good morning. Okay, with regard to CPA AAPUD-22-08, CPA AAPUD-22-11, AA-22-04, I think that's all of them.
That's it. 3.
Yep.
3. Have you had any ex parte communication? We'll start at the end.
Yes, all sites.
None.
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 Site visits on all.
Thank you, Mr. Chair.
Thank you. Okay. The applicant is present. We'd like to have him step forward after we have an introduction from our staff, please.
Yes, thank you. Good morning.
Good morning. How are you today?
Good. CPA AA PUD 2208, Clark A. Stillwell for Nicholas Bloom. This request is to change the future land use from rural residential to general commercial, and to change the atlas from general commercial to neighborhood commercial, and establish a planned unit development for an office. This is an aerial view of the subject property. This is a view of the property from West Dunellen Road. Here you are looking east on West Dunellen Road. Here you are looking west on West Dunellen Road. Here you're looking across West Dunellen Road. Here is the site plan submitted by the applicant. Thank you.
The applicant would like to come forward. Good morning, Attorney Stillwell.
Good morning. Clark Stillwell on behalf of Mr. Bloom, 320 South Highway 41, the Brandon Bank Building in Amherst, Florida. As indicated by the presentation, this is a three-part application. An interesting issue here this morning I bring you, two of them. The application is to go from rural residential to GNC. The LDC Atlas is already GNC, but the application is to take it from GNC to NEC, neighborhood commercial, and then apply a PUD. What is motivating this is the 1,400 square foot building owned by Mr. Bloom. He wants to expand to a 2,400 foot footprint and a two-story building totaling about 4,800 square feet. And there's a last exhibit is a exhibit of that proposed building would look like. Why we're here is basically, I initially filed an application to move this particular piece of property into an MDR district to try and correct the issue of RUR in the plan in GNC under the LDC Atlas. The plan controls, so RUR, if you will, trumps, if you play bridge, the GNC on the LDC Atlas map. In essence, Mr. Bloom's existing office building that's been there since the 80s is a non-conforming use, and it can't be expanded. It's not just Mr. Bloom on this particular stretch of roadway. Both on the north side and on the south side, they have the same issue of RUR, or coastal and lakes, but the roadway in the LDC Atlas map is GNC. So when I first, and to give you a bit of history, in 1990 when the plan was adopted, there was an exhibit to it which called a mapping policy, and it was Exhibit D, okay? In Exhibit D, the mapping policy said about how we're going to go through and designate parcels on the G flume and the LDC. And one of the provisions in the Exhibit D said that if you had an existing commercial use outside of the planned service area, it would be designated commercial both on the G flume and the LDC Atlas map, and that would control. So that took away the problem. And Mr. Bloom enjoyed that distinction on his property from 1990 up until 2004, when the Halls River case came down, and Halls River basically involved an issue of an MXU district on the LDC Atlas, and that's coastal and lakes on the G flume. In Halls River, the court held that the plan controlled, and even though he had MXU, which allowed all kinds of RV parks and mobile home parks and all this sort of things, and multifamily, the plan controlled, and he was bound by the residential restrictions. Interestingly, in that case, Mr. Madoff testified as an expert on behalf of the property owner, and he testified as an expert on behalf of the county, if you can resolve that issue. So, with the decision by the 5th District Court of Appeals in the Halls River case, Exhibit D from the comp plan was repealed. The county created the RVP Mobile Home District and the RV District, and then they went about redesignating all of the MXU districts, and there were a series of them. From what I can research, in 2012, Mr. Bloom's property was changed to RUR and GNC. One of these mass amendments, he didn't get individual notice like the abutters would get within 500 feet. And then he showed up in my office and wants to expand his office building. We filed going to MDR. Mr. Hockadale wrote me a letter and said, you're outside of the planned service area, you're not consistent with the planned service area, and it wasn't sufficient. So then we went back. I had a meeting with Mrs. Coutu, and I said, the gentleman just wants to expand his office. It's been there forever. It's right down the street from a rural activity center. What's the path? What's the template? How do we get there? So we came up with this idea of going to GNC on the G flume, then going to neighborhood commercial on the LDC, and then putting the PUD on top of it. And as you know, the hierarchy, the PUD is going to control over that plan and that LDC atlas. And that PUD can't be amended without a public hearing. So in essence, you're going from a 1,400 square foot office to a larger office on the same piece, and it's been there for a long, long time. No concurrency issues. Since it's been there for a long time and hasn't had any issues, I would say to you there's no compatibility issues. Now, this isn't the first time we've had this issue on this roadway in Dunellen. If you may recall, Nichols Lumber Company had the same issue. Nichols Lumber Company wanted to sell to Spar. Spar needed the rear portion of the roadway redesignated, and they had the same issue, and we took an approach of going to industrial, light industrial, and PUD there on the same roadway further to the east, and you now have that Spar facility, which has been quite successful. I want to say to you that Mr. Bloom did create this issue. He didn't go out and ask for this to happen to him, but I want to emphasize to you that it's up and down the roadway, not just Mr. Bloom's piece, and somehow you have to come up with a solution to this. So it is a major collector. Let's go to the PowerPoint if we can. All right, this is an aerial of the piece. This is a subdivision that's recorded, okay? Series of small lots. I can tell you that the lots, according to the deed restrictions on the subdivision, are authorized for commercial uses. It was done in the 80s. Remember, back in the 80s, all of these roadways, collectors, all the arterials, based on the 76 zoning, had 400 feet of commercial land use designation up until the 90 comp plan, or 86 plan to be exact. All right, next one, please. This is a bigger aerial, and what I'm trying to show to you is where you see County Road 495, that's what's called a Rural Activity Center on the land use maps. It's an area designated outside of the PSA for commercial type uses. You recently approved a Dollar General in this RAC there at 495 in the intersection with 485. Mr. Bloom's piece is just outside the border of that. There's about 6 property owners between him and the edge of the RAC. If he abutted the RAC, directly abutted it, we could have amended the RAC and done that. Okay, next one, please. There's the site plan of the existing building. Next one, please. Survey. Next one, please. All right, so this is your existing G-Flume map, and you can see the yellowish color or tan is RUR, and you can see Mr. Bloom's lots in question. You can see the border of the RAC to the west. All right, next one, please. Now, this is the LDC Atlas map. And as you can see, notwithstanding the fact that the G-Flume is RUR, notwithstanding the fact that the G-Flume is coastal and lakes on the other side, north side of the road, the whole roadway is general commercial. How do we get there? How did this happen? I don't know. It happened in 2012, I believe. Next one, please. All right, this is the abutter map, and you can see a lot of vacant property surrounding Mr. Bloom's property. There is a small warehouse in the north in the coastal and lakes area, and but essentially the area is vacant. It is on a major collector road. Next one, please. And this is proposed site plan. Footprint's bigger. Next one, please. And this is a rendering. So, I understand Mr. Bowman has had some success and he wants to expand. He owns a piece of property. It's been commercial for a long time. I'm trying to get there. I'm not trying to force anything. Okay, I'm just trying to get him the right to expand. And I thought maybe the MDR was a good way to go with conditional use and a PUD. That got rejected, and now here we are with go to GNC on the plan, downzone the LDC to NEC, and then add a PUD, which further constrains the impacts. I understand this is outside the PSA. That issue was addressed in 1990, but because of the history in 2004, 2005, that consistency went away. That's simple and that complex. Any questions?
Any questions from staff?
Yes, please. So your client acquired this house. It was a residential house and permits around 2007. Somewhere around 2009 in aerials, we're starting to see the conversion to commercial without permits. Can you address that?
It's been he's had a commercial use there for a long time. And when you say, what does it take to convert a single family residential house to a commercial use when you just, and we see it all the time. If you if you remodel, sure, you get a permit, but it's relatively just.
No, you need a change of use permit and there's ADA and et cetera, but that's fine. I mean, I hope we don't see it all the time, but we see permits, the permit use. I just wanted to have you address that. There's a couple things in here that aren't matching with LDC that maybe a redesign can work, and I wanted to confirm first. One is the 2 driveway aprons that he's put in. Doesn't mean, can you redesign it with 1 driveway?
And that's fine. In fact, I had recommended that to him, but that's fine.
Okay, and the other one was buffers, the reduced buffers. You've got 5-foot sides, a 5-foot strip instead of 15 on the east and west sides. Can you redesign that?
Can we put the buffers? No, the piece of question, okay, has vacant parcels on each side. So can I put 7.5 feet on one? Do the buffers have to be on just the site plan, or can I split them?
Okay, I just wanted to get we're going to have our presentation. I just want to get your input on the buffer as to justification
We
for
can,
that.
if we put them on 7.5 feet on each side of the property line, that would address that issue.
Okay. No other comments, sir.
Any
But I
comments?
do want, the buffers are to vacant lots owned by Mr. Bloom. So it's not like it's a different party. Thank you.
Any questions from commissioners? Seeing none, thank you very much, Attorney Stillwell.
Thank you.
All right, Hires.
Joe?
Good morning.
Good morning.
Morning, Joe.
Joe Hockadell, Principal Planner with Land Development. This application is requesting to change the subject property from rural residential on the future land use map and general commercial on the Atlas map to general commercial on the future land use and neighborhood commercial on the Atlas to allow for the continued use of the office use on site. So here you can see an aerial of the subject property. And this is the proposed master plan. Now, looking at the records of this property, staff did not find any evidence of a land use change on this. To my knowledge, this has been RUR GNC for as long as I've been here. I started in 2006, and I remember this corridor having that land use when I first started working here. And I'm not aware of any kind of land use change that's been proposed on this property or in this corridor, generally speaking, during that time. So staff is only aware of the 1990 land use being this way. So the property is about 1 acre in size. It is bordered by RUR and GNC, pretty much the same that this site is. It does have low intensity coastal and lakes across the street on the future land use, but it's also GNC on the Atlas. The existing office appears to have been done without permits. Based on aerial records, it looks like the single family home that was there prior to was converted to an office, and a parking lot was added in a about 2009. I think the property appraiser record picked it up about 2015. So if there was any use there prior to that, it didn't show up on any of the aerial records. The master plan proposed is for a 4,800 square foot, 2-story office building. So it would have a footprint of about 2,400 square feet. And also a future development, hopefully this works, yeah, on these two properties over here, which is unspecified as to what that is to be. So the plan does meet most of the land development code standards. There are some deviations basically for landscaping, which Ms. Katu touched on briefly. The applicant is requesting no buffer on the north side along 486, or
No.
488. I was close. Denellen Highway on this side right here, which is where the existing parking lot is right now, where the land development code requires a 10-foot type A. And the applicant is also proposing sodded strips to the east and west, which would be this property line here, as well as this property line here, where a 15-foot type C would be required because regardless of ownership, those are still going to be considered RUR on the future land use map. So the NEC district being requested, and here's an elevation of the proposed building. So here you can see this is the atlas as it sits right now, and this is the future land use. With this request, they're going to go to the NEC on the atlas. The NEC district is intended to serve the area within about a 2 to 3 mile radius. And so here you can see the future land use. And here you can see where it is related to the Rural Activity Center around that intersection of 495 and 488. Which the Rural Activity Center is an area that's designated in our comprehensive plan to allow for and provide non-residential services to a rural population. And so as you can see, this is outside of that. And so the proposed use does not seem appropriate in this area, or the proposed land use. It is not consistent with the surrounding character. As you can see, this whole area back here was platted and designed as a residential neighborhood, and it does have some residences in there. So the area is residential on the future land use map. It is outside the Rural Activity Center. It does not have water or sewer services available, central water and sewer services available, and it is outside the planned service area. And so the request is not compatible with our comprehensive plan, and so all the findings are not positive.
Thank you, Joe. Any questions for Joe?
Yes, I have one.
Yes.
Joe, you keep saying RUR, GNC. And now, how is this inconsistency created? And were the owners of these properties notified that their land use would change to RUR?
I don't know where the inconsistency came from. I believe it was done this way back in 1990. I don't know why that they're different, but it has been RUR on the future land use map and GNC on the atlas, like I said, for as long as I could remember working here. So, to my knowledge, this has not changed. So, I don't know if I can answer why.
Just seems like those two uses are like diametrically opposed to each other, and so inconsistent. It's I can't wrap my brain around it.
Yes, that's correct. They are very inconsistent land uses, and I don't know why they were done that way. So this area has been, like I said, for as long as I can remember, this area has been a confusing area for property owners and staff based on those inconsistent land uses.
Okay, thanks.
Yes.
Driving by and looking at the area, I find that the office building is consistent with the area. Maybe not the zoning part of it, but right down the street was a church. Across the street, a little bit further down, is a cabinet place. There was a place, a beauty parlor. There was a bed place. I mean, there was all commercial type things around. So an office building seemed totally appropriate visually. I'm not sure why you're saying that it's not compatible.
Because a lot of those businesses are within the rural activity center, which is an area designated for commercial uses. This is outside of that, within the residential neighborhood portion of this roadway, basically.
But by the time you blink your eye, you're at the other places. And you're on a major roadway, or at least will be a major roadway in a few years. So they're not gonna put anything that's residential there. So I'm trying to figure out what would be compatible there.
Well, this area is currently designated for residences, so all those lots could have homes on them right now, if somebody were to come in and permit a home.
But that would be inconsistent with living on a main street down the road.
Have to disagree. Unfortunately, the comprehensive plan is the ruling document. That's the ruling document. It's residential. There may be some spotted businesses there. Some of them are in the rural activity center. Some of them are from 1990. 1990 was the time that everything was changed. This hasn't been changed since then. It's been residential on the future land use map, which is the controlling document. And I would argue with it that just because it's a main road does not mean it needs to have commercial. There are plenty of residentials on main roads, but there are pockets of commercial where they're appropriate. We actually had our hands slapped by the state at one time because we had strip commercial on every main road, including this one, and we had to dial it back. Obviously, you know, if you feel it's compatible, you feel it's compatible. That's not what he's trying to say, but that is the ruling document up there, is rural residential. It has not been changed since 1990.
Thank you.
Any other comments or questions? Yes,
Yeah.
Commissioner Stone.
Joe, it might be useful for you to point out that from this rural activity center heading toward, I guess, east toward Denellen, there is no other commercial development. There's nothing but farms and isolated houses, some right up alongside the roadway. So I guess this, to my mind, would be where do you draw a limit? You know, if you draw a limit for a rural activity center that goes to this particular point, do you say, well, you know, it's only another couple of 100 feet, you know, we can add something here, and well, then the next person who comes up here and says, well, we've got this little office building here, we can go another couple 100 feet down the road, and pretty soon you've got this sort of State Road 200 development all along Denellen Road, which right now, other than until you get about to 41, is pretty much all rural, all little farms, and very little of this type of development. And yes, you're right. There is a church next to here, and there's a bar, and there's a convenience store. But those are all in the rural activity center area. So how big do you want to make the rural activity center? Do you go all the way to 41? You know, I guess this is what we're talking about is the limits of development. You know, and at some point you have a limit, you have a line, and how much do you want to let people cross the line? Particularly for this particular facility, which has been unpermitted forever. The owner certainly had no urge to make his facility permitted and legitimate within the county code. So now he's asking us to extend, you know, the rural activity center, basically, is what this is talking about. And the rest of the road is very consistent. It would not be consistent with commercial. It's consistent with rural residential. Oh, I said that for you. Okay, thank you.
Any other comments, questions?
One question.
Yes, sir.
If you're gonna ask, you need to come up here, please, sir.
In the GNC district under the LDC, it's a single-family use of permitted use on a major road.
So the land development code says for a general commercial district, a single family home can be placed in general commercial if it has access to a local street and is in a residentially committed area. But this is rural residential on the future land use.
Well, would
Again, up to the mic, please.
if you wanted to build a single-family house in the LDC Atlas was GNC, would you need an LDC Atlas amendment?
Actually, probably not. The flume controls, and the flume is RUR. So in this case, it would be a very good case for a house. Yes.
So we're supposed to be looking at this as a service for the local neighborhoods in this area, as far as if you put up an office building. What would you consider a use on a local level for an office building? For the residents? Would you look at a doctor's office, a dentist's office, maybe a CPA? Would those be the type of neighborhood uses you would expect out of an office in this type of neighborhood?
Those are good examples.
Okay. So this business, based on Attorney Stillwell's comments, it's for contractors for mechanical, electrical, plumbing, and general trade services. Does that fit into a local residential office building that would serve the local residents, in your opinion?
A trade contractor? Yeah, I would say that was something that would be able to serve the surrounding area.
Okay. All right. Thank you. Any other questions? Thank you very much, Joe. Okay. So the public portion, of the meeting will now be open. If there's anyone present in favor of the application who would like to speak, please come forward to the podium. As a reminder, individuals have 3 minutes to speak and an organization have 5 minutes. When speaking on this application, please address the board. If you have any documentation that you want to be entered into the record, please provide a copy to the recording secretary. Is there anyone wishing to speak in favor of this application? Anyone wishing to speak in favor? Anyone wishing to speak in favor? Is there anyone present who would like to speak in opposition to this application? If so, please come forward at this time. Anyone in opposition? Anyone in opposition? Seeing none. We will allow Attorney Stillwell any final closing statements, sir?
Mr. Bloom's use has far less impacts than a doctor's office or a dentist's office or a CPA office. He has no traffic. This is all done internally over the internet. It's really a unique kind of business. I tried to figure out how to describe it, but what he does is he evaluates people's electrical systems and then he gives them advice or utility systems on how to make them more efficient. There's no coming and going here. So it's not that intense. You got two issues here. You got Mr. Bloom's problem. He wants to expand. He's had some success on his piece. And then you got the other issue, the bigger issue. The elephant in the room is you're telling people on your LDC Atlas map that this is commercial. And it's not just Mr. Bloom, it's a mile up the road. These people are walking in the PA's office, they're pulling up the all key numbers in the printout. You know what it says? Commercial. Doesn't say RUR. Doesn't have a big asterisk on the GNC designation like Mark McGuire's home run record. Okay. So those are the two issues. There's Mr. Bloom's and then there's the bigger issue, and you're the planning board. So whatever you vote today for Mr. Bloom is one thing, but I suggest to you strongly do your job and figure out what you're going to do with this roadway up there and tell these people the basic facts. Because someone's going to buy a piece of property up there. Mr. Bramlett, some realtor is going to go up there and say, oh, it's commercial. You know what happens. And then what? Thank you.
Thank you. At this time, the public hearing portion of the application is closed. I will return it to the board for comments and discussion and a possible action.
Mr. Chair,
Yes.
Madam Attorney, I have to say, Mr. Stillwell's argument about this inconsistency is very compelling. And this is the biggest thing that I'm not wrapping my head around is how we got here and how we're going to solve this problem, because this is going to happen again. So what is your legal interpretation of where we stand with this area?
This area is similar to other areas. I don't know what was in on the minds of the Board of County Commissioners in 1990 or the Planning Board in 1990 when this situation happened. But where we are today is a situation where you are either going to, he tells you to do your job. So your job is to follow the law, right? So the law currently is the situation that we have, and you can either upzone everybody or downzone everybody. You can't piecemeal the up or the down. And what he's asking you to do is extend the RAC, which currently there's a line, and it hasn't been expanded. If you guys want to make a wholesale change to upzone or downzone, and the Board of County Commissioners wants to either upzone or downzone, I don't know who's going to make that decision. And how are you going to make that decision for all the property owners along there? This gentleman bought the property with the zoning as it is today. It's been here since 1990. I don't know why Mr. Stowell said 2012. That's just not flat out not correct. So that's either you piecemeal it, and y'all know how that goes, or you leave it the way it is and wholesale changes are made as appropriate. But I don't know who has the wherewithal, whether this board or the Board of County Commissioners has the wherewithal or the desire or the chutzpah to either upzone or downzone all of these properties. I don't know who has that.
Would there be instances where people could unsuspectingly purchase properties, conceivably thinking GMC?
No.
Okay.
Unless you think that people don't have to have personal responsibility
No,
for
yes.
their decisions. That's within your purview. When a person buys a piece of property, they're charged with investigating. The realtors, I don't think a realtor is going to say, oh, I forgot to look at both the G-Flume and the Atlas map, because I don't think a realtor is going to take on that responsibility. So I think the realtors are going to do their job, and the people need to do their jobs. And this gentleman, as you know, bought this in 2007 with the existing zoning on it. So it's up to y'all. But as to do your job is to follow the law. And if this board wants to make a wholesale change and recommend to the Board of County Commissioners that they make a wholesale change all up and down there, or Mr. Stillwell wants to present an application that wholesale changes either up or down, you got to go up or down. And who's going to make that decision?
Does this board have the authority to do that? County commissioners ultimately make that decision,
Correct. And this will go to the Board of County Commissioners too.
But from my perspective, this is spot zoning. It's kind of like one application, there'll be another one down the road, one a little farther down the road, one across a road. So where does it end? Is my question. And do we ultimately have a decision, the responsibility, or the authority, I guess is a better word, for this board to make that recommendation to the county commissioners?
If I could jump in, earlier this year, the board actually did across the road change it the other way from commercial to residential on the Flume because they wanted to do a residential use. So you have gone both ways in this exact area. Or applications have gone both ways.
So if I understand you correctly, you're saying that the north side of the street is now residential?
It has the same inconsistency, but they applied before this board and the commissioners and were successful to change their Flume their Atlas to residential to match the Flume. They downzoned themselves.
Yeah, that wasn't too long ago.
No, that was this year.
wasn't too long ago. So,
That was my exact question to Jack, those people that built that house across the street.
okay, I'm not sure what this is.
So if we wanted, if I can understand this correctly, can staff recommend to our board to make the wholesale change? Would that start with staff making the wholesale change along this road, and then we would debate its merits and then make a recommendation to the Board of County Commissioners? Would that be the process if we so wanted to tackle that?
If you could, yes, but I would caution you, Mr. Stillwell is going to be representing some of those people before you if you try to downzone their property. Right? So then you're going to be Bert Harris claims, oh, you're taking away my property rights. Oh, my property, these properties have been zoned this way since 1990. Do y'all realize how long ago that was? No one has touched the zoning on these properties for all that time. If this inconsistency was such a horrible thing, you might have seen someone doing something about it before now. But they haven't. No boards of county commissioners, no planning boards. Mr. Stillwell's been in the county since the dawn of time. He quotes to you all the changes that have gone on in the county since the dawn of time. If it was such a big problem, why hasn't it been taken care of until now? And if it is time, then you need to have the appropriate study, and the Board of County Commissioners is going to have to decide whether it wants to take on the responsibility of either upzoning or downzoning. And it's a huge question. And we deal with it all the time. There are other places within the county that the county is looking at. I don't know whether y'all saw the study recently, where at the interchange management areas, there are properties there that are going to either be upzoned or downzoned based upon that. And so taking those big chunks of land and making those seriously important decisions are not, you can't take those things lightly. And I don't know how long these corridor studies have been going on. Did y'all actually do that last time, or was it canceled?
We did it.
The interchange management? Okay. So y'all did that. So, do you do it piecemeal, or do you do it like you're doing there, where you're taking a big chunk of land and making a whole thing out of it, for lack of a better word? I can't answer why this happened, but it is what it is. And how do we change it? Is it a matter of staff bringing it forward? I don't think it's going to come from staff. I think they're going to have to get direction from the Board of County Commissioners that this is a problem and initiate it that way. Staff's probably not going to do that. And that's how the interchange management areas came forward. The board decided they wanted to study the particular areas, decided to fund it. I think we maybe got some grants to do that. But it's expensive, and you may have to pay out some money to people that have been relying on the existing zoning for a long time. It's not an easy question.
Thank you.
Mr. Chair,
Yes.
I am not in favor of this application. This business, I feel for your client. I understand what you're trying to do is just make these changes to this area in order for him to expand his business, and I'm glad he's had success. However, I feel residential is appropriate for this area. We have a rural activity center that makes sense. The zoning makes sense to me, and I'm not in favor of piecemeal upzoning. And it's outside the PSA, and they don't have access to central water. So I'm no.
Any other comments?
I'm just going to echo what Mr. Stone said earlier. He basically said all of the same points and highlights that I was talking about. We've dealt with this in the past with people that wanted to change a PSO zoning to GNC, and it butts up to residential. And the particular reason that properties were zoned PSO is to create that buffer where you don't have the high intense commercial uses adjacent to residential. This particular property, I've driven past it for a very long time. I remember watching the transformation happen. I do understand the inconsistencies, and I think that there should be something done about that eventually. I'm not smart enough, nor do I get paid enough up here to try and say that I'm going to figure it out, but I would be willing to put my brain into the thought process if somebody would spearhead it. But this particular property, the fact that it was switched from residential to commercial without permits, and it is outside the RAC, I'm not in favor of the application.
Any other comments?
Yes,
Yes, Commissioner Stride.
I am in favor. I feel that changing the entire thing is just too large a parcel for us to handle, whereas this one building makes sense to me for this one application, and I am in favor.
Any other comments?
I'm not in favor of the application because of the unpermitted activity over the past, and I can't see changing the potential residences that they want here.
Any other comments? I will echo Commissioner Roy's opinion. Without the permits in the past, that's somewhat annoying to me. You know, we're supposed to get permits, we're supposed to do everything, you know, correctly, and then you got the house and you went to commercial and nobody ever bothered to do something. Now all of a sudden there's an issue and now we're supposed to correct this, so I will not be in favor of this application either. Any other comments?
I mean, I just would make mention that just on the other side of the 495 and 488 interchange, there are quite a bit of homes, residential homes built along this particular roadway. So when Miss Gregg said that, you know, you're not going to put in residential, that's simply not true. There's a lot of homes there and they're all filled up. They were built, they were sold, they've been resold multiple times. So residential along a roadway like this does in fact happen quite a bit.
Okay. Any other comments?
Mr. Chair.
Yes.
The Planning and Development Commission finds application number CPA-AA-PUD 2208 inconsistent with the Citrus County Comprehensive Plan and Citrus County Land Development Code, and that this board recommends denial of the application to the Board of County Commissioners based upon the evidence and testimony presented and the staff report and conclusions regarding this petition.
We have a first, do we have a second?
Second.
We have a first from Commissioner Worthington and a second from Commissioner Royce. All in favor signify by saying aye.
Aye.
Opposed?
Aye.
We have 6 opposed. Motion fails. Motion passes. I'm sorry. Apologize for that. Okay.
Mr. Chair,
Yes.
might I have to say something.
Yes, ma'am.
Mr. Stowell and I go back a long way, and I probably should not have joked about him being here since the dawn of time. That probably was something I shouldn't have said, so I apologize, Clark.
Thank you for your comments. We appreciate that. Our next application is CPA AAPUD 22-11. If we could have an introduction from staff.
Yes, thank you.
Thank you.
This request is to change the future land use from low-density residential to general commercial, and to change the atlas from low-density residential and general commercial to general commercial, and establish a planned unit development for a mini warehouses and covered RV and boat trailer parking. Here is an aerial view of the subject property. This is a view of the property from North Lecanto Highway. Here you're looking north on North Lecanto Highway. Here you are looking south on North Lecanto Highway. Here we are looking across North Lecanto Highway. And this is the site plan submitted by the applicant. Thank you.
Thank you.
Mr. Chair, I'm
Yes.
sorry. Clark, would you mind just 1 second? I see people here that were here for application CU-21-13. They're probably looking around like, where is that right now? Is it okay if we just mention that they've asked to reschedule that? I don't want to make an assumption that you're here just for that, but if you're wondering where that application is, it's been rescheduled.
Yeah, I apologize for that. I thought that had been noticed already. CU 2113, Natasha Griffin Esther School has been rescheduled to December 1st. We will send out new notifications for that meeting. That's at the request of the applicant.
Thank you, Clark.
Thank you. I apologize. I didn't
No,
realize
thank
that was an
you.
issue.
Good morning again.
Good morning.
You got the name and the address, different client, different area. The request is 3 parts like the prior one. This one involves an amendment to the eastern side of the property from LDR to GNC for 1.86 acres. The Atlas map is being amended also. And then a PUD on top of it for 5.45 acres for proposed use of mini warehouse and RV type vehicle storage. Map amendments are proposed are consistent with the elimination of the split land use districts that occurs on arterial roads. We just had a discussion about that. Front 400 feet historically has always been GNC, and they were mapped that way 1986, you know, back when I was just a child. 1990 and in 2012. The key PUD is consistent with the GNC district, and it's consistent with the whole commercial corridor. You're talking about 4 buildings and approximately 91,500 square feet. The buffers are proposed on the north, east, and south. The site plan on the PUD has all of the drainage there on the eastern side of the parcel where it would abut to residential property. So when you look at the site plan, you're going to have the required buffer, and then on top of that, you're going to have the drainage retention area, which will enhance the setback off the residential. The use is far less intense than other GNC uses that could be done on the 400 existing frontage of GNC. Within your backup material is a traffic engineer's report. And that traffic engineer's report was done for 2 purposes, but it documents the low intensity of the amount of traffic these type of facilities have. The peak hour, which is during the weekday, PM and AM peak hour traffic impacts is basically 12 to 14 vehicles per hour. That's peak hour. That would be morning and evening, 9 to 9:30. 4:30-ish is the traditional peak hour. The additional GNC in this area is consistent with your comp plan. Policy is 1764. It sets forth all the criteria, and each of those criteria this additional GNC meets, particularly with the PUD. So I'm not going to speak a whole lot about that issue. Let's go to the PowerPoint, and then we'll talk about what is really interesting. You got a PowerPoint? There we go. Okay, you can see the survey in the rear portion, 1.86 acres. Next one, please. Thank you. Here's the G-Flume map. You can see the strip commercial along the roadway. Next one, please. This is the LDC Atlas map. Next one, please. Okay, what do we got here? Okay, this is the abutters use. You can see to the east is one single family house on a very large piece of land. You've got a cell tower. To the north, you've got a church. And then to the south, you have commercial, but it's a residential use there. The 2 pieces to the south have residential uses. Across the street, we have the county's mosquito control district. And Joe's got a comment about them. Next one, please. This is the site plan. Now, the driveway access point is 250 feet south of the property line for the church. It's 120 feet north of the property line for the commercial property to the south. Commercial property to the south, approximately 25 feet off that boundary, you have an existing driveway for a single-family residence. We have a cross access to the south. There's no cross access to the north. Now the 2 issues, let's go to the next one. You can see the drainage retention area. All right, this is where it gets interesting. Your county code requires 440 feet between driveway separations on this roadway as expanded. Even when it expands, and it's it's going to be expanded, they're condemning property and it's paid for. The initial proposal from the county to my client was that they would not have a driveway cut on 491, and that they would access off of the existing church driveway, and the church driveway would be expanded. And this is kind of one of the concepts that they came up with. The church objects to this strenuously. So next one. This was done by the county engineer at my request, the engineer that's doing the road expansion, and it shows the turning movements of these larger RVs if you were to utilize the existing church access point, even if expanded. One of the issues here is you see the church drainage retention area there right along the property line, which makes this very problematic. And this is not what you would call good best management practices. Okay, next one, please. This is the area that the county said that they were going to condemn of the church's property for a public access so that my client could access onto the church's property. Next one, please. So, again, this shows that proposed area. You can note that the church has a drainage retention area to the north along its north property line, so it can't cross access into that particular piece, and there is no cross access into that particular piece. And the church's site plan has no cross access. That's in your backup material. Next one, please. Again, this is more of those turning movements in the problem. So from, next one, same thing, I'm sorry. Next one, please. From this proposal, we went to a proposal with the church where we were going to split it right down on the property line. My client would donate some property, church would donate some property, and that would be a joint entrance. That was rejected. The next step that we proposed, Dr. Wilburn proposed, was we redid our site plan and we were going to put the joint driveway 100% on our property. That is, the church would come in through the Sulphurn property and turn left, and their driveway would be removed from 491 and would be a joint access point. That was rejected by the church. You're getting the theme here? So we came back to the point, and then the county has told us, can we go back, ma'am? Keep going, keep going, keep going. Then the county advised us, this is October, I want to say early September, late August, they are not going to do this. They are not going to condemn that property for that access point. So what they're taking is a small strip of land off the church, and then they're taking approximately 20 to 19 feet off of my client's property. So and when you look at planning condition number 5 and your recommendations where it says there'll be a joint access point, at this point in time, the county's not prepared to condemn that, to make that happen. So condition number 5 can't happen. That gets us to the basic point of we got to have access. We don't meet the separation standard. If you read the expert's report, okay, and the code says you can get a 20% deviation off the 440 feet separation, okay. If you read the expert opinions report, there's minimal traffic from the church, minimal traffic from this facility, okay, and the accident history on this roadway is there, and it's there's not a lot of accidents, very few accidents. So the expert's opinion is this would be a safe driveway access point. He said you could move it to the north 20, 30 feet, but it is safe and it would facilitate access into this particular parcel. Now the church has been adamant that they don't want any RVers coming through their property, and they've told us that many times. And so when we did our site plan, we showed cross access, the 120 feet to the south into the other piece, but no cross access into the church. And you have a letter from the church that says they don't care about the land use, they don't care about the RV storage and the mini warehouses. They just don't want cross access on their property. And frankly, I don't know a lot of people that are going to go to church on Sunday morning and then stop in at their mini warehouse and do whatever they're going to do. And I don't know a lot of people that are going to go to the mini warehouse during a weekday and then decide to go to the church, which isn't open. So cross-access on these two uses doesn't make a whole lot of sense. The expert report does recommend that at the time of permitting, to mitigate, and that's what your code requires when you deviate from the separation, to mitigate it recommends decel lanes, even though given the number of trips, that would not necessarily be required. In other words, what I'm saying is, if this driveway was 440 feet away from the other driveway, given the limited number of turning movements, there wouldn't be a requirement for a decel lane. Your code says mitigate to get the separation if you want to reduce it, and his recommendation is at the time of permitting, you do a study and figure out what the decel lanes are. He said there's no need for acceleration lanes. So there you have it. We are entitled to legal access. The county is not going to condemn the church's property to provide us legal access there. The church has rejected 3 different proposals for joint access. My client wants to use its property and they're entitled to legal access. Traffic report says this is a safe access point, even though it doesn't meet separation. Now, there are numerous examples on this roadway where the 440 feet driveway separation standard is not met and has not been met. Those are historical, I admit that, but they're there and they don't have a whole lot of issues relative to traffic safety. I told you I was bringing you interesting applications this morning, and here you have it.
A lot of brain power today.
Questions?
Any questions from staff?
Yes, please, thank you. Condition number 5, FYI, we realized to recognize there's ongoing discussions with engineering, so it has been reworded, and Joe will put that as part of the presentation. We also have Cindy Jones from engineering here, saying that cross-access to the north and south and access management acceptable to the county engineer. I'm paraphrasing, but he can do that.
What does that mean? To just do my simple, the county engineering wants cross access to the north and south, but the driveway where it's shown is appropriate?
No, they're saying that these are ongoing discussions, except whatever is acceptable to the county engineer, not committing to any specific location of a driveway apron, if at all. This is something that we're putting it in their ongoing discussion category. We realize that this is still a work in progress.
Just to give everyone a proper framework of where we are time-wise, if the driveway location can be identified within the next 45 days, then the county's road construction plans can be appropriately modified to provide for that. If it's done later than that, then the county's road construction plan would have to be subject to a change order. And if you know anything about construction business, change orders are expensive.
And we'll let our engineering staff talk about that. The other thing, in the staff report, you can see that staff does not support your deviations for buffers on the east side to residential and along 491. Can you address that?
If we can get an access point, we're fine with your recommendation.
The east side buffer as well?
Yeah.
Okay. That's it, sir. Thank you.
Any comments from the
Oh,
commission?
sorry.
Oh.
FAA, not FDA, FDOT, with the mosquito control. We have been approached by mosquito control concerned about maybe or maybe not this would have an impact on their flight path. We are putting a condition in that you do have to look at the construction use permit process. If it turns out it is an obstruction, go through that. It may not. No, I don't think anybody's done the legwork on that yet, but any comments on that?
All right, so Joe sent me that after the staff report came out. And basically what mosquito control is saying is their helicopters come in from east to west. This property, they're coming in at about 100 feet, I'm told, up, and this property is about 70 feet elevation. Mr. Wilburn is here, he can tell you how tall these buildings are. We don't see an issue with that.
Okay, we're putting it in just in case that you have to comply. I mean, you have to anyway, it's land development code, but just wanted to hear your comments on that.
It's a first, you know, I've been here since forever, and this
Yeah,
is a
forever.
first.
The hangar hasn't been there that long, so thank you, sir. I swear I'm done now.
You're never going to live that statement down.
It's gonna stick around for a long time.
I think we'll both use it when we need it. While I appreciate Mr. Stillwell's commentary on the county's road project, I can advise that there were several condemnation lawsuits that were filed very recently. I know one of them was yesterday, so I don't see the county's road project moving as swiftly as Mr. Stillwell has indicated.
I can only pass along what Mr. McLean has related to me. Now, let me say this. We have signed my client signed a contract to sell.
The church hasn't.
Yes.
The church is still in negotiations with the county for condemnation, so it's actually very unfortunate that this is coming through right now because, as you know, when people are in negotiations, they are not as
Friendly?
agreeable. I said agreeable.
You know, I have to say, we made a really good faith effort here to try and work with the church. And I can understand their position. But I just want you to know we made that good faith effort. So, and Mr. Wilburn's here. He's the engineer. He designed the project. He can answer those questions. And he also has had discussions with the church about issues. So, if you have questions.
Yes.
It's very, I'm
Oh, go ahead,
sorry. It's very difficult to have hearsay presented. I mean, if the church has these strong opinions, I'm not sure why the church isn't here. And I trust Dr. Wilburn implicitly, but still, you know, everyone telling you what the church said or didn't say is
Well, you
kind of
have the
difficult.
letter from the church on file. You have that. I'm sorry to interrupt.
Mr.
Okay.
Stillwell, did you reach out to the property to the south to try to set up some sort of joint access with that property owner?
I did.
And
I got no response. They are getting 2 driveway cuts on their property. The existing driveway and then one to the south of it, which inexplicably doesn't meet separation either, but that's what has been resolved, I'm told. More hearsay.
When he's talking about driveway cuts, he's talking about I'm sure you
median.
all understand that the county is undertaking a many $million project to make 491 better for all of us, not just the individual property owners that live along there. And so what he's talking about driveway or cuts, he's talking about median cuts.
No. I'm talking about, you see the little driveway cut down here to the south?
So there's no median cuts? The only median cut is up there by the church?
That isn't a median cut. That's a controlled access left-hand
no,
turn only into the mosquito control. So there's a raised median in front of this property, the church's property, and the property to the south. You'd have to go back to the aerial.
So access would only be northbound
Northbound,
only.
keep going all the way
Right
back.
turn
No,
in,
the
right
blue
turn
one.
out.
Keep going. 'Cause,
Didn't you want the one with the blue?
next one I think is, nope, first, all right, there's a street down there. What's it called?
Fennessy?
Fennessy. That's where the median cut is on the road design plans. The road design plans are in the traffic engineer's report in case you want to look at them. But that's
So
where-
if all those property owners had cross access, they would all access the cross access down to Fennessy out onto the highway,
if they had it,
as required by the code.
if they develop it, yeah. And that's exactly what we've done. We've shown 120 feet to the south in our plan.
Well, what about Dealey's property and the property above?
I don't know about Mr. Dealey. I do know that the drainage retention area for the church in the northwest corner in the church's parking lot prohibits any kind of cross access there. So it's like it's going to stop right there.
It can be moved.
You know, there's a reason why the county's not condemning the church's property. And the
We're s-
reason why is they have a real issue whether or not they can meet the constitutional test of whether that serves a public purpose versus,
Well, I haven't talked to Campbell, so I don't know if that's his concern, but from what I've been told, the church is not in a lawsuit, and we are in continuing negotiations with them. So as the board knows, the county tries not to go into lawsuits for condemnation. The county works diligently with property owners to try to come up with a settlement that everyone's happy with. And my understanding is the church has not been sued, so there is no lawsuit, and we are in discussions with them. I just talked to Campbell yesterday. I don't know when's the last time you talked to him.
last week.
Any other comments from the board?
Bottom line, we're entitled to access. Bottom line,
Yep.
we're entitled to access.
Can we go to the site plan, please?
Sure.
Okay. If I read the information correctly, the current flow of the water is to the southeast corner, and that's going to be maintained. Is there a swale that this is discharging into, or is it just overland? I'm just curious as to how the drainage is gonna work.
Mike Wilburn, Local Engineering Inc. Currently, how that would work is we would, obviously at this stage of the game, there hasn't been a lot of engineering design, but the way this is laid out, you can do it one of two ways. A lot of storage facilities will drain in the aisleways and an inverted crown right to the DRA, depending on the site and depending on how high these buildings end up being in terms of elevation. There may end up being a few box culverts, so conveyance would be through stormwater piping. You're accurate that that's the way the water naturally goes, and obviously it's better construction-wise, cost-wise for the client if we keep water flowing that direction. So in this particular layout, it would flow east to west between the two buildings and then discharge into the pond, either conveyance on top or through a stormwater system of inlets and pipe.
The property boundary that you have shown, does that have to be reduced at all on the 491 side with the construction of 491, or is your property lines perfectly established now and you have no impact?
The site plan based upon the taking after the fact.
Okay. Which then leads me to looking at the entrance. Your entrance road appears to be extremely short.
You talk about the throat.
Yeah,
We call it the throat.
The distance from 491 into the parcel looks extremely short. There's going to be a keypad, most likely, I'm assuming, to function a gate. And one of your vehicles, I think it was the fifth wheel, is 60 feet long. It looks to me like you may have a storage problem trying to get the vehicle in there and get to the keypad and not have it hang out into 491. Has that been looked at? Because obviously that could impact how your buildings are laid out and where they are.
First, and Mike can speak to this, when you have access into these type of properties, the access road has to go into an aisle. As you turn right, you could go straight down an aisle. That facilitates the internal flow. That's the first thing. The second thing I would say to you is, because we have the cross access to the south, and it's required to be there and be available, the security fence is gonna stop, and the keypad is gonna be further off the road. That cross access has to be available to the public, otherwise it doesn't work. So the keypad or the secured access is much further off the road than the norm. But Mike can also speak to that.
For clarification, am I speaking right now in terms of the initial presentation? Okay. So, the land development code gives criteria for how big you have to have a throat distance. And as Mr. Stillwell mentioned before, according to the International Trip Manual, this facility is going to generate about 12 to 14 trips. Interestingly enough, they've done other studies recently where the ITE manual has been shown to be 2.5 to 3 times conservative. So in real life, maybe there's 5 trips around 5 trips in a peak hour. However, because of using the ITE, which is required, our throat distance meets the 30-foot throat distance in the LDC, and that's what's shown here. I think it's 32 feet. But as Mr. Stillwell said, when you look at this site, traditionally you would think that it's a secured facility, but because there's cross-access, the gate locations have to be strategically placed. And you can see there's parking across from the middle building and a red rectangular area showing office. That has to be on the outside of the gate also. So when an RV, like you mentioned, a 60-foot total length vehicle pulls in, they'll actually be pulling in, if you look, they'll be 30 feet to the beginning of that cross access, then another 20, and then that's a 25-foot radius. So that's 50, that's 75 feet right there just to the start of that building where that vehicle will go. So there's plenty of room there, and also that vehicle can turn to the left and continue going up. None of this that you see on site, none of these aisles are 2-direction. They're actually wider than what the LDC requires. Instead of a 24-foot aisleway or even a 30, because of this use, these are all 30-foot, and some of them are 40-foot aisles. So vehicles can go in both directions.
Okay, so on the bottom of your site plan, it says a 10-foot type A buffer, 6-foot chain link fence around entire perimeter of property. So that statement has to be modified because it's not going to be around the entire perimeter, because it's going to have to kind of jig and jag around there, if I understand you correctly, in order for you to have access to the south and for you to get to the office space, correct?
Correct. Let me see if I can do this. We see these. The fence is going to have to come here, go up, and come here.
Okay.
It's
All
going to jag out.
And, all right, that's what is the confusing part here, because it says the perimeter. So I'm just making sure that we don't end up with a problem down the road. That's why I wanted to bring it forward.
In Michael's defense, when the client acquired the property last year, okay, when I got involved, I asked them, have they been contacted about the condemnation? Oh, by the way, just, they're out of Boston. And they didn't know anything about it. So then I picked up the phone and called the county attorney and Mr. McLean, who handles these matters. He says, we've been looking for this client for a long time. I'm glad you found him. That's the truth. So this started literally in July. And we've had to react to this very quickly, and that's why we use the word perimeter on the site plan, just to get it. I appreciate your comments. I'm just trying to tell you, as you can see, this is a work in progress. We're every week is a different scenario.
All right, thank you. Any other comments?
Thank you.
You're welcome. Joe?
Good morning again, Joe Hockedale. This application is being requested to change a portion of the subject property from low-density residential to general commercial and establish a plan unit development on the property in its entirety. As Mr. Stillwell stated, it is about 5 acres total in size. The portion being changed is about 1.86. So here you can see the aerial. This is the existing land use. So you can see it's got general commercial in the front already and low-density residential in the back. And this is what they're proposing, to have the whole thing be GNC, which, as you can see, based on some other properties in the area, that depth does seem to be consistent with some of those other properties. So this is the approved master plan. The applicant is requesting about 91,000 square feet of mini warehouse and or boat and RV and boat trailer parking, and that is to be used interchangeably. So they could have mini warehouse buildings, or they could have the covered boat storage, or possibly even uncovered boat storage in the areas you see as red, as kind of how they want to do it. And they are also providing a 600 square foot office, which does have parking out front of it. So based on the master plan, there were some deviations being requested, specifically with landscaping. The Land Development Code requires a 25-foot type D buffer on the south property line where it abuts adjacent LDR, and a 25-foot type D on the east. The applicant has requested a 10-foot type C along the south and a 20-foot type C along the east. Based on the area, they have enough room to do the 25-foot type D landscape buffer. We've had the discussion about the walls in the past. I don't know if the wall necessarily would be a requirement here. The property to the south is currently undeveloped. It does have the split zoning, so it could develop as commercial in the front, it could develop as residential in the back. And then the property to the east does have a single family home on it right now. If you look at the contours of the property, basically the elevation increases as you go northeast. So this home up here is probably 20-25 feet higher grade than this site down here. So would a wall be necessary? Probably not. But they do have the room to put a 25-foot type D. And then the Land Development Code requires a 25-foot type C along the right-of-way of 491. This is large non-residential design criteria. And they're proposing a 10-foot type A. But again, they have enough room up front they can put in the required buffer. As to access, I could try to speak to that, but it would probably be convoluted and confusing, so I'm going to let Cynthia Jones from our engineering division explain that.
Good morning, Cynthia
Morning.
Jones with
Morning.
Engineering Division. So as Clark had said, county staff has been working with them on access to the site for quite a few months. The original proposal that we had with the shared access would have been a full access connection, as opposed to what the connection that they're proposing now, the 250 foot south of the northern connection is going to be a right-in, right-out only access. And so I'm not sure if that had been clarified or not. So with the proposed location where they have it now, if they want to go southbound, they'll have to exit right out of the site, go up to the first available turnaround and come down. Same thing with somebody coming southbound, will have to go all the way to Fennessy and make a U-turn to come back to the site. And there was a question about the separation of the driveway, the cross-access from the 491. That we do have gated entrance standards at the code, so they'll have to comply with all of those standards. That'll make sure that the gate is set back far enough. With regard to the cross-access requirements, the code and the comprehensive plan do require cross-access, and that would be required to the north property line and to the south property line. That cross-access has to be outside of any fenced-in storage areas that might be proposed, and I believe Clark did mention that. One thing that I didn't see on here on this plan, probably because of timing with preparing the plan and other things, is the compensation that was provided for safety, which was the right turn lane coming into the site. So that would be a requirement for the 250 foot separation. And one thing we do require is right-of-way dedication for a turn lane when that's provided. So that would need to be shown in the plan as well. Sorry. And if you had any questions, or is there something I didn't address?
Any questions from Commission? I have a couple for you.
Certainly.
You indicated that right turn in, right turn out, and that the vehicles would have to do a U-turn, whether it be the north of the site or south of the site. In the design plans for the widening to 491, will these vehicles that use this be able to make that U-turn? Is there going to be enough of a radius? Has that been looked at yet at all?
Yes. Yes.
Okay.
So on Fennessy, there would be the access going to the mosquito control That is not a U-turn, and that would have to be signed as, and I believe it's in the plans, no U-turn. So there, they would have to go to the next intersection, which I thought that showed on these plans from the traffic report, but they don't. So it might be Horace Allen. I'm not quite sure how far north they would have to go.
I think you also said that if a right decel lane was constructed, there would have to be right-of-way dedicated to the county
Yes.
along there. How does that impact the property to the south of this? Would the county look for an acquisition of that property, or how would that be addressed? Because it would be, the decel lane obviously would have to cross both
Yes,
properties.
it would. That's something that the applicant will have to look at. It's a requirement of the comp plan
Okay.
to provide right-of-way dedication. I mean, there's some roads where we have a lot of right-of-way, but in this particular case, we just have enough right-of-way to do our road project and additional turn lanes. We don't have the right-of-way for that.
Okay. All right. Thank you.
All right, thank you.
Any other questions? Any questions for Joe?
Oh, I'm
Oh,
still
I'm sorry,
presenting.
Joe. I apologize. You did such a good job. I thought you were all set.
Well, thank you. So with the access issue discussed and clarified, here you can see this is the church site to the north, and this is what the site would look like were it approved. And again, as you can see, what they're requesting does seem to be compatible with the depth of some of the other GNC properties that are in this corridor. The site is located within the planned service area. It does have access to central water and sewer. As you can see, the site does have a mix of both non-residential and residential uses, although, on the corridor itself, it does tend to trend non-residential. And having the PUD does limit the development to the mini warehouse and RV boat trailer storage. And so the findings of fact were all positive. We do have the suggested conditions. There have been some modifications to those, as we discussed. So the one that I had discussed with Clark is I did get a call from the director of mosquito control. He did express some concern with their flight approach for their helipad, which does run pretty much east-southeast. And so I do have an additional condition, which is a construction use permit must be acquired if development is considered a potential obstruction within the airport height notification zone per section 7500. So basically what that means is if this development does provide any kind of hazard or obstruction to that flight path, they've got to go through the proper channels to get that approved, or they've got to bring it down. And then there was a modification to condition number 5 that was proposed by engineering. So number 5 would say a northbound right turn lane will be installed by the developer as recommended in the access evaluation report. Right-of-way dedication for the turn lane is required in accordance with the multimodal transportation element policy 10.b.4.1. And then there would be an additional condition recommended by engineering that is, well, actually, my apologies.
I struck through the original number 5.
Gotcha.
And rewrote it based on the plans.
Gotcha. So then the one I said previously would be the new condition. And then this would be the modification of number 5. Access to the site shall be via a non-residential driveway apron at a separation of 250 feet from the northern driveway apron. Cross-access to the north and south property lines will be required, which cross-access must be located outside of any fenced storage area, which I believe would take into account the concern you expressed before with the fencing.
Any questions for Joe?
Joe, before you finish up, can you go back one slide on this presentation? No, keep going. I'm sorry, it was a church picture. Yeah, is that a stub? Wait, too fast. Is that a stub out? It looks like a stub out on the aerial and there. Yeah, that's a stub out.
Yes.
They've done a stub out for cross access. The church has. Okay. So there's an existing cross access to the north. I don't think that was said before.
Any other comments or questions?
I just had a question, and we've had a lot of discussion about the cross-access. I didn't see a cross-access, an area that I saw as cross-access on the site plan. Is that something that will be worked out, negotiated with the engineering department?
Right. So yeah. So one of the conditions says that they have to provide it. So if this gets approved, they will then have to modify that plan to provide that cross access.
Any other questions or comments?
I have a question.
Yes, sir.
Who is Walt Eastman?
Walt Eastman is, he's actually the interim engineering division director.
Okay. I'm just, because I read this packet and then I'm reading it again, and he's just talking about the, if the abutting property owners do not agree to the shared connection and cross access, and then how he explains with the interim driveway. And that's what you're talking about, Miss Jones, correct? And
Yes. Well, yes. Walt is the engineering. He works in engineering. He's the engineering projects manager, and he reviews the plans and works with the consultant that we hire to prepare the plans. And he works with the attorneys. I'm sorry, you said the name. Anyway.
Walt is he coordinates the condemnation with our condemnation attorneys.
Okay.
Sorry.
I mean, based on his statements and emails, he's pretty knowledgeable and he knows what he's talking about. I feel like he has a pretty good grasp of the situation. And a couple of his statements, as long as the county and the property owners are in agreement, I feel like there's sufficient evidence to prove that the access would be handled properly. I wish that the church property, and maybe they will, maybe they won't, would be a little bit more agreeable to try and do what's right for the county and in the entirety of the situation with the widening of the road right there. If they don't, they have that right as well, I guess.
We're still in negotiations with them.
Okay. Yeah. And listen, we've dealt with it before. The car wash, for an example, the abutting property owner didn't want to do anything, whether it was right or wrong. So I'm not really sure I was going with that part of it. I'm just wanted to make the statement that who that Walt guy was, and then based on his conversations, it sounds like it's going to be handled in an appropriate manner that's going to be effective to everyone in the situation.
Question.
Yes.
I do have a follow-up on Commissioner Bramlett's comment. If the negotiations with the church conclude in the very near future, and maybe the church says, okay, now they're in favor of a shared access, how does that impact our vote today?
I think the condition is, I think it's condition 5. It allows the parties to continue to work together to
Just wanted to
make the
clarify.
best project for all involved.
Just wanted to clarify.
And the engineering department is the overseer of what they determine to be the best scenario and outcome for that particular problem or resolution to the problem.
Yes, I think it says acceptable to the county engineer.
Yes,
Okay.
county engineer.
Yep, just me.
Okay. Yes.
Okay, if the church was developed according to our land development code, our current code, and they have the stub out, doesn't that require them to connect?
It does.
So why or how could they refuse?
We're in negotiations with them.
Read between the lines.
Okay.
Any other comments or questions? Thank you, Joe and Cynthia. Anybody from the public wishing to speak in favor of this application? Anybody from the public wishing to speak in favor? Anyone wishing to speak in favor?
He did not.
Not-
I looked at him and he didn't kind of jump up. But
I was going to allow him to rebut after we got any public comment, in
was
case
with-
anybody had
it
anything
was with
else.
staff. He didn't get a chance to ask staff.
Thank you.
I thought we rebutted after public, not.
That's,
Not rebutting. He never had a chance to question staff.
Okay, yeah.
you'll get your chance, Clark, I promise. Anybody in opposition? Anyone in opposition? Anyone in opposition? Seeing none? Mr. Stillwell, the floor is yours.
Point of order, Mr. Chair. If no one from the public speaks, then what is he rebutting?
No, speak to the staff conditions as
He's-
modified, which I got this morning. Thank you.
My apologies, that I let things get out of order.
See, she hasn't been here and you've been,
You're slipping.
now you're put on notice.
I have to follow the law.
Robert's rule.
So, and I wanted to follow up on Mr. Facemeyer's comment. Assuming there was a deal and there was a joint access driveway, you're telling me I am not going to have to come back here for a public hearing to modify my PUD.
I think the condition, oh,
Right, can you read condition 5 again, please? The modified.
Yes.
I just don't want to have to do the dance again.
We don't want to see you again either, we worded it.
Right, yeah.
You're
So this
getting
would be,
Beat down today.
It's not just him, I never want to bring people back from minor
Right,
things.
sure.
Go ahead.
Well, good. That's all I need. Okay.
Right,
And then
yes.
as I read, so you understand the conditions that I've read, okay? It allows us an access point at 260 feet south of the church's access, which is fine. As Ms. Lynn and I both said, we're entitled to access. Now that could change, but this will codify that portion. It does say they want cross access to the north and south. Well, we propose to the south and we reserve the right to debate the issue later going to the north, which is fine. The desal condition is also fine, but I want you to understand how it works so everyone knows. And if I'm wrong, Cindy, you tell me. When we go to permit this, we will do an engineering study that indicates the length of that desal lane, okay? And yes, we have to dedicate the road right away. Now, that desal lane, I don't know this at this point in time, but that's what the study's for. It may be 3 car lengths or 4 or 5, or it may just be 2. But that's how it works. There's no specific 150 feet worth of desal lane, because 150 feet puts us into the abutting property to the south, which we don't own. So are we clear on how that's going to work? Yes, there will be a desal lane. Yes, that provides the mitigation for safety under the code, but the exact parameters of it in the design comes at permitting. All good?
Yep.
Okay.
Okay, going back to the board. Do we have any comments, questions, concerns?
I have comment just based on cross access and the particular widening and plan that they have for this particular area. So cross access, we're talking about undeveloped properties to the north and to the south, but this area is quickly developing. Everybody knows that. Nobody knows it better than the land development department. And then you can just see it by the roadways when you drive around. I think that cross access in this area is a very smart planning for the future. Especially when you have those U-turns, there's not a right in, right out, or a median cut directly in front. U-turns are never a good idea. People take them at the wrong times, and I think those, what I call them, service roads, because I'm used to being up in Tallahassee and all along Appalachia Parkway right there, which is Highway 19. They have service roads for that entire area right there, and it just brings all of that congestion off of the main road, and there's the turn-ins and the turn-outs to the commercial activity. I just think it's good planning.
Any other comments?
Just a question that probably our attorney can answer this. And it's just a general knowledge question. Can you give us an update on the status of the 491 road widening project?
it's so nice that you guys miss me when I'm not here.
We
I
do
can
miss you.
I can tell you that we are experts, and I say experts because it's more than just our lawyer. Our planners, our engineers, the lawyers, they are working diligently. The Board of County Commissioners are pressing the issue. I can tell you very, very much they want this done. So, unfortunately, in my call yesterday, I learned that there are still 5 properties, which we are still, unfortunately, are unable to reach agreement. Some litigation has been filed, and so our project cannot move forward until all of the right-of-way acquisition is completed. So Some of the bigger properties, and like Mr. Stillwell's client, have entered into agreements, which is very helpful. Those are give and take agreements, but we do still have some, unfortunately, that we had to sue. So those
So
do
still
delay the
right-of-way
process.
acquisition.
Still in right-of-way acquisition, but I believe that the planning and the engineering is moving at the same. They're on dual tracks, so it's not like that is on hold. But from my standpoint, the litigation standpoint is, that piques my interest because I know how long litigation takes. So hopefully we're going to resolve these, even though litigation has been filed. There's always the chance for settlement. So it's moving along. I know that our administrator, Randy Oliver, is just on it every day with staff, pressuring them to get everything done. So it's a huge deal for us. I think everyone in the county staff is aware that we need to get it going. So we're trying.
Thank you.
Any other comments or questions?
Yes, I have a question.
Yes.
Mr. Bramlett, so what are you saying that, because I think from a planning perspective, the best access is the shared access with the church at the meeting where they don't have to do the U-turns. So are you saying that you're not in favor of this application as presented because they're not having the driveway where it would be best placed?
No, because condition number 5, I'm trusting in the county engineering and the property owners and Mr. Stillwell and the engineers that are involved in it to ultimately do what's best for the location of the access.
Wouldn't they just, if we did that though, then they would be allowed to have the interim driveway until, no?
Correct. Right. Whatever Walt Eastman.
Yeah, they're going to have, the way the condition words, they've got to have the cross access. And if the cross access works out in everyone's best interest, then that might happen up there rather than there. But what Mr. Stillwell is saying, so at a very minimum, this is the plan that I can have. And we've said yes, but you still got to do something with the cross access. It may be that old plan may be resurrected, which would be a beautiful thing. For everyone, but he's protected that at least he gets this, at the very least, with the cross access, and that might just be a little cross access. But hopefully not. Hopefully it'll all come together.
Any other questions or comments? We've had a couple of different storage facilities come before us, and we put hours of operations as one of our conditions. I would like to add that to this one also. And I think we had looked at something somewhere around like 7 a.m. to 9 p.m. I don't know the exact hours,
Why?
but it was somewhere in that area, and I would like that to be a condition of this operation
Why?
also.
Why do you say that?
Why not?
What
That's what we
those
did.
those
wanna
were in
dictate
like
how they run
those
their
were in
business.
predominantly
No, all it is-
residential areas that we did that. There were residential areas that was predominant in that particular area, and we were dealing with some strip commercial zoning along the main highway there that utilized it, and we had neighbors that came in here and they expressed a desire to not have the RVs running at certain times of the hour, which was what dictated that. But this is in a mostly predominant commercial area that's going to have a 4-lane highway with in an area of significant future growth in the county that I don't agree with putting a restriction on the hours of access to.
All right. Just as a side note, I have a storage facility at Windmill on 44.
Yep.
And they have restrictions, and that's on a commercial roadway also. I think that doing this, it does help us, particularly you do have that home that's up on the northeast corner that's there. I think that we're not going to harm them by doing from 7 a.m. to 9 p.m. They're still going to have their ability to have people enter and exit. We're just not having that disruptive motion while those residents might be sleeping at night. That's all I'm looking at.
I'm not in favor
Yeah,
of that.
I don't agree with that. I understand your position, but I don't agree with it. That's a 4-lane county highway, a main highway. There's going to be traffic at all hours of the day. And this is just a storage facility. So it's not like there's people out there with air wrenches and doing construction and heavy industrial type activities that's going to be loud and a nuisance to the area. So I respect your comment, but I don't agree with it.
All right. Any other comments or questions? Seeing none, can we have a motion?
Mr. Chair, for the purpose of the
Yes.
motion. The Planning and Development Commission finds application number CPA AA PUD 22-11 consistent with the Citrus County Comprehensive Plan and Citrus County Land Development Code, and that this board recommends approval with conditions as amended of the application to the Board of County Commissioners based upon the evidence and testimony presented and the staff report and conclusions regarding this petition.
Second.
Okay, we have a first from Commissioner Bramlett and a second from Commissioner Facemeyer. Any discussion?
I just want to clarify, did we remove the requirement for the wall along the back?
No, the condition right now says per LDC, which would require the wall. But if you would like to make that modification, we can do that.
I like walls.
I don't.
I like walls in particular situations where walls are deemed fit, and I'm glad that you brought that up, Ms. Worthington, because in my opinion, a wall is not a wall isn't a necessity on this particular application.
Because the DRA being in the back,
I'm sorry?
because the drainage in the
Because the
back.
drainage, yes.
Can we get a consensus then to modify that condition?
I would be in
So-
favor of modifying that condition. Mr. Bramlett.
Yeah, so I would just amend the motion to include that modified condition,
So that would,
whatever number that is for the buffering.
that would modify condition number 2 where it talks about the type D buffer. It would say without a wall.
Yes.
Is that consensus? I heard from 2 of you and then I heard from 1 of you no, so.
I've been out modified, so.
Well, I don't know. Nobody else with a no wall, right? I mean, with a wall required. Okay, moving on.
All right, so we have a motion, first from Mr. Bramlett and a second from Commissioner Facemeyer, and the only modification to the condition that we just talked about was no wall on the type D buffer, correct? And then the other 2 that were read earlier. All in favor of the motions, please signify by saying aye.
Aye.
Opposed? Motion carries. Okay.
We'll miss you when you retire, Mr. Stillwell.
Whenever that is. You've been saying that for years.
Have a break.
Sure. We'll take a break until 5 of 11. Let's get back to it. AA 22-04, Joseph and Heather Flynn. If we have an intro, please.
Yes, thank you.
You're welcome.
AA 2204, Heather Flynn. This application proposes to amend the Citrus Springs Unit 17 Master Plan to allow 2 single-family residential lots on a tract currently labeled for future development. The site is about 2 acres in size and lies on East Anton Drive in Citrus Springs. This is looking northwest on East Anton Drive, with the site on the right in this photo. This is looking southeast on East Anton Drive. This is looking southwest on North Dora Way from East Anton Drive and the application site. Much of the surrounding area is currently undeveloped. This is the proposed replat of the site if this application is approved, which would create 2 single-family residential lots. Thank you.
Thank you. If the applicant would like to step forward and make your presentation.
Good morning.
Good morning.
My name's Heather Flynn. I don't have much of a presentation. We do own the 2 acres. We're requesting that the zoning or be changed from future land use to single-family residence. And we do have a application in for a replat to make 2 separate 1-acre lots. Most of the property in the area, the majority are smaller lots, 1/3 of an acre. So it seems consistent to make this single family.
That's it?
That's
Okay.
it. Short and sweet.
Any questions from staff?
No, sir, thank you.
Well, any questions from commissioners?
I have a question.
Yes, sir.
Joe Flynn, the contractor?
Yes.
Okay. And these homes will be intent, spec, sell, custom?
Probably going to give one lot to my son.
Okay.
Who is a law enforcement officer. He's assigned to Marion County, but this is within the
Okay.
parameters.
Owner occupant? Okay. Just curious.
Yep.
Any other questions? Thank you very much. Staff?
All right, this is an application to amend the master plan of Citrus Springs Unit 17 from future development to single-family residential. And pointing out the aerial here, you can see there's a lot of undeveloped land, but it is residential area. You can see Citrus Springs Boulevard down there to the south. I'll talk about the area in just a moment as far as relative to that. This is the actual Citrus Springs master plan for the area. This was done before the future development track. We have these all over the Citrus Springs. I put in the staff report a quote from a department director long ago. We have no idea what they meant by future development, just someday they'll figure it out. Because of that, and because there's so many, department director long ago said, let's give them one house in a future development tract. They can have one house per tract. That's fine. And then anything more than that, we'll have to see them before us. So she can already do one house. This would allow her to do two. You can see that's where it's located right there. It is a lot of record. It was replatted into subdividing. It's not reflected here. All those white areas are single family. You can see some commercial down there on Citrus Springs Boulevard. There's a church site in purple and a school site up there in orange. Doubtful it'll ever be developed as a school. It's pretty small. But this is the area. They have surrounding lots. Now, let me point out, too, she did talk about correctly that these lots are much smaller than what they're proposing. They're proposing 2 1-acre lots. These are anywhere from 1/3 to 1/2 acre in size surrounding it. So this would be single-family residential, abutting single-family residential on a residential roadway, but they would be 1-acre lots, which are bigger. So this again is the replat that was submitted. It has been approved by staff pending the outcome of this application that will allow them to put 2 houses on the site. That's all I have.
Any questions for staff?
Go backwards.
Thank you very much.
You can put up the aerial, please. Thank you.
Sure.
Somehow I whizzed past it.
Time for the public to step forward if anyone wishes to speak in favor of this application. All right, feel free to step forward.
Sometimes it's hard to say whether you're in favor or opposition.
Right, so
Good morning. My name's Pete Hedke. My wife Linda, we live over on Dora Way. We recently moved there about 2 months ago. And Citrus County is a nice place to live. We lived in southern Florida, southwestern Florida for about 6 years. So we've seen urban blight at its very finest. And I mean its very finest or very worst, whatever you want to look at. Urban blight being an overpopulation. I don't have any legal ramifications or anything like that to discuss up here, but I do have an opinion in that Citrus County is a nice place. It's a clean place and has the cleanest water in the world. And I think we have a responsibility to try and maintain that. And what I'm going to suggest is probably ludicrous to some, but I think that we should consider at least a limited moratorium on development in Citrus County. And I know that to a lot of people that's a horrifying thing, but down the road and looking back, it's really a good thing. I moved from a place where they have that, or they've done that in a county, and then as the urban blight went somewhere else to develop, that county has still maintained, and it's still a very nice place to be. So that's my only comment, and I'd like the county to consider and look at that, because this is an opportunity that may not come along for a long time. Thank you.
very good. Thank you. Anyone else wishing to speak in favor of this application? Anyone in favor? Anyone in favor? Seeing none, we'll move to anybody in opposition. Anyone in opposition? Anyone in opposition? Seeing none, we'll close the public portion of this hearing and return it to the board for actions. Any comments from other commissioners? Seeing none, if we could have a motion?
Well, I'm sorry, I didn't speak fast enough, I guess.
Step to it.
Sir, I just wanted to say thank you for your comments and opinions. Unfortunately, a lot of these properties are platted and by right can be developed, and there's no way that we could put a moratorium on people's personal property rights. So while I heard your opinion, in this case is a little bit different, but in most cases, from a development perspective, these people have a right to their personal property and to develop it by the zoning and the appropriate standards that they have on their land. So I understand what you're saying, and it's definitely a delicate balance that we're all trying to navigate right now as Citrus County is in a growth time. But we're trying to balance, and as you saw probably in the first application, we kept the rural area rural. We did an up zone. So we are following the law and balancing the interests of the growth and then also the desire to keep this small town charm that we all love. That all being said, I am in favor of this application.
Thank you. Any other comments? Seeing none, do we have a motion?
I should have noted, I do have conditions, I apologize.
Oh, okay.
They're in the staff report, basically, that it's two residential lots plus land development code standards.
Right.
Mr. Chair,
Yes.
purpose of a motion. The Planning and Development Commission finds application number CPA-AA-PUD-22.
No.
Oh, wrong one. Sorry.
2204.
AA-22-04, consistent with the Citrus County Comprehensive Plan and Citrus County Land Development Code, and that this board recommends approval with conditions of the application to the Board of County Commissioners based upon the evidence and testimony presented and the staff report and conclusions regarding this petition.
Do we have a second?
Second.
We have a first from Commissioner Worthington and a second from Commissioner Scraggs. All in favor signify by saying aye.
Aye.
Any opposed? Motion carries. Okay. The only additional item that I'm aware of is that we received the dates for our PDC meetings in 2023. Unbelievable, we're almost at that point. Crazy. Any other comments from staff?
Yeah, a couple things. First of all, we only have one applicant for our alternate on the PDC. So if you know people that have always said, I want to do that, tell them to apply. Now's the time. We're trying to fill the one alternate position. As far as your meetings, you have a packet before you for October 20th. There are 2 applications in there, and Mr. Stillwell verbally told me this morning that he is withdrawing his one application in there. I will send out, have Cheryl actually send out emails when I get confirmation of that. So in your packet, you really need to review, not review the Stillwell one, assuming that he does follow through in writing on that one. In November, we've got two on one meeting and 3 in another. December is really got a lot of huge applications, hundreds of houses and hundreds of thousands of square feet of commercial coming before you in those 2 meetings. I know it's the holidays too, so if you can't attend, we have one alternate who's wonderful in showing up, but let us know when you can. If we have to push things back, we will.
Should we hold on to the application for that school?
No, because it's going to change slightly, which is why it was postponed.
Any other comments? Seeing none, meeting adjourned.